Going back to where I started. Here we go. What a disaster. Hopefully the Supreme Court has their crap together better than I do. So let's back that thing up. I guess you guys read it on my screen. So let's see, where am I at here? Get me off of the screen. So I'm sure you guys, hopefully you read, I was just saying that the Indiana Supreme Court is going to give 20 minutes each. I watched a previous oral argument and it's very quick. So the 5 justices come out. In the middle will be the Chief Justice is a woman. On both sounds, it will be, on both sides, it will be 2 guys, 2 other justices. And she'll say what the hearing is about. She'll introduce each side. So I think there's 3 sides today. One is Mark Lehman on behalf of Richard Allen. I'm not sure if Todd Rokita is he's the Attorney General in Indiana. I'm not sure if he's going to be speaking on behalf of Judge Gull in the state. And then the third party is possibly the Indiana Public Defender. So I'm not sure if each one is going to get 20 minutes. In the previous argument that I saw, there's 3 lights in front of the podium. So it's going to turn green when they start talking. I believe when there's 2 to 3 minutes left, it's going to turn yellow just to notify the speaker that they have to wrap it up. And then as soon as it turns red, they pretty much have to stop speaking. After about 2 minutes, when they start, the justices will interrupt them looking for clarification. So expect the 5 chief justices to be speaking, looking for more clarification. The one, so just so you know, no decision is going to be made today. Obviously, we're seeing if Judge Gull is going to be removed, if Baldwin and Rosie will come back. And then the third item is whether or not they will get a speedy trial in 70 days, which some people have said it really doesn't matter if that's decided upon, because at any point, Rick's defense attorneys can file a request for a speedy trial. All right, I'm glad you guys can hear me now. What's next? So it's starting in about 18 minutes. So I have a reminder on my phone to check. So hopefully, I said before, which obviously you guys did not hear me. So underneath, underneath this video you're watching right now, in the description box, I pasted the link to the official Indiana Supreme Court website that I'm going to be streaming from. Yeah, I don't know what's going on. People, please be nice. If you're a moderator, just ban people who aren't being nice. So if you don't want to watch my stream, I'm going to provide the link below so you guys can watch it in a different browser and then come back here if you want after it's over. So I did have these other slides, which was kind of like reviewing how we got to this point where it just seems like it's so far away from where it should be, but hopefully we're headed in the right direction. So I have this timeline of defense. October 4th, on a call, Baldwin and Rosie told Gull they intended to file for a speedy trial, and the trial was set to start 10 days ago. Obviously, that didn't happen. So October 6th, 2 days later, Rosie emailed Gull, McClelland, and Baldwin with the subject line, leaked info, with a possibility that crime scene photos had leaked. The F tree photo is already public on Facebook. Rosie just learned of it in the last hour. He called McClelland, who knew for the past day or so. October 8th, Gull replied and was disturbed and wanted an update on the investigation. She recalled back in December 2022 when they communicated about Baldwin's email with evidence to Brandon Woodhouse that he sent by mistake. But I said here, this goes against Gull. Oh, sorry, Siri is asking me for something. I said that when I was looking at other documents, it goes against her saying in the October 19th chambers that the court and she did not know about the Brandon Woodhouse incorrect email until May of 2023. October 9th, around 4 p.m., Mitch Westerman told Baldwin what he did, which he went into the conference room taking photos of Abby and Libby at the crime scene. At 4:48, Baldwin emailed Rosie, and the next day, Rosie opened that email. There was a conference call between the 4 of them, Baldwin, Rosie, Gull, and McClelland, where Baldwin said that Westerman went into the conference room at his office in August and then sent those photos to the man with the initials RF, who committed suicide on October 11th. And disqualification of Baldwin and Rosie was first mentioned in that phone call on the 10th, 9 days before this hearing that never happened. October 11th, Allen wrote to Judge Gull stating that Rosie told him McClelland requested Baldwin and Rosie be disqualified as his attorneys. Rick did not want them removed. So is Rick the person who should be making this decision, or is it Gull's responsibility to try and determine who is the best attorneys for Rick? October 12th at 4:07 a.m., McClelland replied that RF committed suicide. So about 3 hours later, Judge Gull read that and replied, quote, "This is beyond tragic. Once again, I'm at a loss for words. I'm deeply concerned that Mr. Allen's defense is being compromised by all these recent events. I will have my staff schedule a hearing in Fort Wayne for next Thursday, the 19th, 2 p.m. to discuss these recent developments and the upcoming hearing on October 31st. Mr. Rosie and Mr. Baldwin, please cease work on Mr. Allen's case until we meet on the 19th. 5 days later, Rosie emailed Gull requesting a meeting about what will be discussed on the 19th. And so the day comes for this hearing. I guess Gull did not reply to Rosie with more clarification. So in Gull's office, I think they started at 12:30, an hour and a half before the public hearing. Gull told the defense she was concerned they were grossly negligent and incompetent, and they could resign or go into the courtroom to hear from the state's witnesses regarding the leak of photos of Abby and Libby's bodies, and hear Judge Gull disqualify them in front of everybody, and also is being broadcast live. Baldwin said he resigned, and Rosie said he would resign in writing. He later admitted he did not intend to do this. Timeline of defense removal. I have this here. So up here it says, this is Judge Gull. So this is from the October 19th in chambers meeting. So Gull says, and then, that brings us to my concerns that I raised with all of you on our phone call. And I write everything out. And this is what I intend to say in open court. I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Candidly, my concerns began at our hearing on November 22nd of 2022, like a week after Baldwin and Rosie were assigned. Mr. McClelland filed a motion for a gag order, and we were in chambers, and you assured me, gentlemen, quote, "We don't want the media in our lives. We will not try this case in the media." And then less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. I don't know. I think you knew or should have known those were potentially violative of Rule 3.6 of the Rules of Professional Responsibility. But it is that press release that prompted me to issue the order December 2nd, granting the gag order until further hearing. So she said she's like kind of upset with what they were doing for almost a year. October 25th, Rosie filed to remove Judge Gull and continue as Rick's attorney. The 27th of October, Gull appointed 2 new public defenders, William Labrado and Robert Scremin. Those guys, I don't know if they'll be in the peanut gallery today, but they're not presenting. October 30th, Baldwin and Rosie filed to appear as Rick's private counsel, also known as pro bono, which they were saying, okay, we'll represent Rick for free. The next day, Gull said she could not allow Baldwin and Rosie to represent Rick due to their gross negligence. We have about 10 more minutes before we're going to start, or the Supreme Court will start. I kind of went through Gull's reasons, so let me go through why they want Gull removed, and then I'll get to your comments. Let's see. So October 30th, this was a relator's brief in support of petition for writs of mandamus and prohibition filed by Richard Allen and 3 attorneys. I think Mark Lehman was one of the persons who signed this. He's going to be the one presenting today. The summary is Judge Gull is allowing documents to be hidden from the public, and she did not follow proper procedures. A, hundreds of documents are improperly excluded from public access. B, Baldwin and Rosie filed a Franks memo, and the trial court sua sponte removes it from the public CCS, which is known as the chronological case summary, without notice or hearing. Sua sponte or sponte of one's means of one's own accord is a decision made or action taken by a judge of his own accord, with no motion or request having been made by any party to the legal action. C, the trial court attempts to effectuate the removal of Allen's chosen counsel over his objection and without his consent or approval. D, Allen instructs his chosen counsel to make filings on his behalf, and the court orders the clerk to remove those filings from the case file. So November 6th, Relator's brief in support of petition for writ of mandamus filed by Richard Allen, Mark Lehman, and Kara Weinecke. The summary is reinstate Rosie and Baldwin because they were wrongly forced to quit, replace Gull, who is biased, and set a speedy trial within 70 days. So this is what prompted today's hearing that's starting in 10 minutes. Allen requested and was appointed competent and experienced counsel. B, Allen's lawyers issued a press release affirming his innocence. C, due to his declining mental and physical health, Allen asked to be moved out of maximum security segregation. D, Allen and his attorneys formulated a strategy of seeking a speedy trial and pursuing a defense of third-party guilt, which I think essentially means the Franks memo where they said Odinus killed Abby and Libby and not Rick. E, the trial court removed Allen's chosen counsel over his objection. F, to continue pursuing Allen's trial strategy, counsel remained in the case as private counsel, but the court disqualified them. So this is Todd Rokita, the Attorney General, was kind of saying that he did not think today's hearing was necessary. It should not be granted because there are other ways to address these issues. I'm not going to review this. All right, let's see what you guys are talking about. So for people just joining, I am going to show, let me see. I'm going to stop this. Hello, everybody. I decided to use a tropical thing since some people are cold all around the world for my background. Share screen, share. So that's hopefully going live 2 minutes before, so about 7 more minutes. I'm not sure if I'm gonna have to refresh, but I do have a reminder to hopefully refresh it on time. So once this starts, I'm going to point my microphone at my computer so you guys can hear and see the live stream. I'm gonna go in the other room on my laptop and I'll join the chat from there because I don't want to be typing in here and have you hear that background noise. Hopefully it's gonna go okay. Hi, Sammy. I haven't followed this case in a while. Is there still any doubt that Allen did do it? Yes, there is some doubt because I have not seen 100% evidence that Rick was the killer. There's this whole issue on April 3rd. He called his wife and his mom from jail and said he killed Abby and Libby. According to the prosecution, they said he admitted several times that he killed Abby and Libby and that he was guilty of the crimes he was charged with, which is bridge guy, kidnapping Abby and Libby. So we're going to have to wait for the trial to hear all the evidence, but I don't know. I mean, in the Franks memo, which was released September 18th, his defense listed about 6 or 7 items based on August depositions of Holman, Liggett, and also Lesenby, which said that Rick's DNA was not found at the crime scene. His phone did not really connect him to Abby and Libby. His social media did not connect him to Abby and Libby. So there are certain things that point to Rick's innocence, but there are other things that point to his guilt. So we're going to have to wait and see what the official evidence is and how whoever Rick's attorneys are going to be, how are they going to try and disprove whatever the prosecution presents. I was going to do a poll, but I'm going to do a poll as soon as the hearing starts. Hi, DNA King. I didn't know the judge took down the defense motions. This is highly unusual. It frankly makes me think there's something to all of this conspiracy stuff. DNA King is a defense attorney, so he has experience with some of this. So yeah, I guess after Gull said that Baldwin and Rosie were not competent, she removed some of their filings after October 19th. I don't know, Brandy, I don't know what's going on. I don't know, when I get in the chat later, hopefully I can help you out with something. Hi, Grunstruck. I guess you're saying at the trial, whenever that happens, we'll get to hear the entire audio from Libby's phone. Yes. I don't know if they're going to show the video. I would assume they would show it to the jury. I don't know if they'll broadcast that, if the trial is going to be broadcast. DNA King says the defense doesn't need to disprove anything. I know it's the burden is on the prosecution, but what is the defense going to say about Odinus killed Abby and Libby and not Rick? Gen X Rando says that wind chill here is -7 and the tropics make me bitter. Oh, sorry. Hi, scumbag Trav. I bet we will be shocked at trial. Yeah, I'm not going to be surprised to be shocked. It's one shock after another with this case. I think there is a lot more circumstantial evidence that shows Rick is bridge guy, and having already put himself there and changed his actions while there, he's going to have a tough time. Well, this whole issue is in the 2017 written tip that the conservation officer took or typed up. He said that Rick said he was there between 1:30 and 3:30, but the conservation officer can't find the audio recording, which would prove, did Rick say a few days after the murders that he was there 1:30 to 3:30 before he knew certain details, if he truly is the killer? And then October 13th, 2022, when he's being interviewed by Liggett, he said, no, I was there noon to 1:30. The police are saying that the Hoosier Harbor Store camera at 127 shows Rick's car headed towards CPS, not away from it. So that 127 video of Hoosier Harbor Store is one of the pieces of evidence I'm most interested to see. Does that car totally match up to Rick's car, therefore indicating he's lying? Danielle says it might be the case, but they only have to provide reasonable doubt that it was not Rick. DNA King is correct. They don't have to prove anything. Okay. All of you guys should be hosting live chats, not me. Shelley says Gull should get in trouble for removing the files from the public. She's done this over and over again. I believe she blamed the clerk for not filing it properly to, there's a certain form, I think it's called an ACR or something, that needs to be filed for when they make these documents private. And they were not doing that. And some people were saying even this most recent motion to transfer by Rick's new defense attorneys, an affidavit was secretly taken off the public filings, but this ACR form was not filed. Hi, Run the World. Aloha. Hi, Loki. Grunstruck. I wonder what will last longer, the Delphi or Idaho 4 trial. I don't know. Good morning, Steve. So I'm waiting for this background website to refresh. It says, let me refresh it. I just refreshed it. It didn't show. The video player will be available 2 minutes before the argument is scheduled to begin. I was saying before, I might have been on mute. We had some technical difficulties. So there were other hearings at 9 a.m. There's a 40-minute hearing. 10 a.m. they had another 40-minute hearing. This one is at 11 a.m. local time. It's supposed to start fairly quickly, so hopefully my screen is going to change, and then I'll show it here. As I said before, I'm going to go in the other room, and I'll join the chat from there, so you can't hear me typing on this in this room. Danielle says the defense pursuing a speedy trial makes it curious to me how much evidence the prosecution has at this point, or maybe it's just some sort of strategy. Well, Rosie said that he had Rick sign the request for a speedy trial last August, and yet they had not submitted it by mid-October. So even by October, that was, I guess, 3 months before the trial was supposed to start, January 8th. So why would they even be considering filing that? Some people say, oh, the prosecution isn't ready. Well, I don't know about that. I mean, they have all the evidence, so either Rick is guilty or not. So let's, refresh again, it's starting. Fixed it. All right. Wait.
All rise. Supreme Court of Indiana is now back in session.
Good morning and welcome. We're here this morning to argue in the case of State XREL Richard Allen Relator versus Carroll Circuit Court and the Honorable Fran M. Gull Respondents. Counsel for Richard Allen, the Relator, will argue first. We're hearing this case on a writ for mandamus and a prohibition case. Representing the Relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnecke. Good morning, Ms. Winnecke, and Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana at council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Fran Gull, and you will be arguing first. And at council table, we also have Chris Stake, who's also here on behalf of the respondent, correct? Good morning and welcome, Mr. Stake and counsel. Counsel, as we've been conducting oral arguments, you'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes. So you ready to proceed?
I am.
All right, Mr. Lehman.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that this court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impied the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes. And his licensed counsel, who both will remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes. And then when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality, they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserved that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that You
have a lot of concerns, but I've got you've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial was.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't
maybe if
involve.
there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Concern? Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive whatever Strickland violation might occur were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judge, says, I'm aware of that. I know what's happened. I'm ready to ride or die with these lawyers.
I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, and you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counselor, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She found his representation was grossly negligent and incompetent.
She said you're grossly negligent and incompetent. I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Yeah. Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Bolden and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Wait, Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action, the judge. I'm going to go out there and I'm going to say these things, and Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more, because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe,
Because
Your
you're
Honor,
saying there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
correct, Your Honor. I do think I don't think
Without
those
a hearing.
positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the
So
6th
my
Amendment
concern is getting
requires.
this case back on track. All
Yes.
right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error and it'd be reversed, and everybody would have to go through this again. Correct?
Yes. Judge, but I do want to clarify that this is more than just the choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the
A
case.
lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it. It's in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery. Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation, because one is the lawyer is not being a lawyer at that point. They're
Not filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea, because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think there are rules that an actual conflict of interest is unwaivable when you sue one party versus the other, and shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts,
And
other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that, Justin. No, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial, and that fully and fairly advise him that that's a repercussion. But if when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
well, counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance to counsel.
But even if it did?
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did had nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case, it'd be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples. These are good examples of that. In that the inadvertent disclosure of pretrial discovery the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent
No,
that from happening?
I think if there's a concern, say, for example, the pretrial publicity, the press release, if you say, listen, I think, because the violation says it has to affect a fair trial. So, okay, you're going to have a hearing, the judge could have a hearing, let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Counsel, I want to.
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
Structural error.
at least fundamental error, maybe structural error that's reversible?
Trials for show. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could. Because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing Respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, to the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make these judgments, but reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to protect the defendant from his own lawyers. But it's hard to look at this record and not get the impression that perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under the United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
of counsel.
struggling with that. I'm, butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing, we don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited, and that right may be outweighed by any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying, a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril. And this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court, one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles, that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even asked for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence, and frankly, then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So
Well,
your
tell us why you
solution,
think that Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective.
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations, right to select counsel, are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so
violation.
I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, There are interlocutory appeals. There are emergency interlocutory appeals. There are appeals after final judgment. There's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What
The
about our 1982 precedent? So State versus Tippecanoe County, the shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in two ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here. Under the United States Supreme Court's jurisprudence in Wheat, the decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done, there's a way that you do it, and it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of procedure.
So there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on. I think you're incompetent and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing and presented evidence. They didn't do that either.
Would any of those actions have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed. So, which means.
Well, we won't know what would have
that.
happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I appreciate you looking out for our original action jurisprudence and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material
Can you
and
help me
attorney work product.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience, to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel
I keep
capable of
getting
making?
back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just what we're talking about here. He wants these attorneys. And so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney to get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat waived that conflict.
It was a major conspiracy with lots of different people playing, in the Wheat case.
Wheat
I don't
himself,
see Wheat as tucked as neatly as you find Wheat. So
Wheat
go outside Wheat and give me something else.
well, but again, Wheat himself claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But
on
where can you point to me saying, with regard to saying somebody is incompetent or negligent? We have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly not consistent with the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool that is polluted.
Does that rule apply both ways? Because one of the things defense counsel said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent, as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find disqualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause the significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings. And it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork to exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold conditions precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel or we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me offer
Wouldn't that
this.
protect everyone's interest in finality in the long run?
We really don't know what Mr. Allen wants. And it was not necessary for the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly on this record has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you,
Your
Mr.
Honors.
Gutwein. Ms. Sanchez.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions. This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself. What
would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up.
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary. that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that may well have been about an active investigation, evidence that may well be relevant to a full understanding of the conduct that is of concern to the judge. Of course, the summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the truth-seeking function, and for the fact that everyone will
Do you
believe.
agree that with, under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made in the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case. And then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The
significant
default rule,
weighted.
something like it?
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below. I think it's reasonable when looking at if that is in fact what the judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But
be
there's
sufficient.
no other case out there where a judge sua sponte on her own motion disqualified based on her finding, her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in.
But for these reasons, it
but-
could be conflict, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with a larger record to explain exactly what the judge means, because of course we presume, we're inferring from that choice of words and the particular thing cited by the judge, what she meant by analogy to the use of ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm
in these
clear,
cases.
you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say, no relief today. Is that right?
No, we don't think it's a writ. There's no order, there's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so, even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see that my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. There is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? Is that, we don't know? All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Gull, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what their ethical rules require them to do, which is to do zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The Attorney General and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half-measure justice. So we'll accept whatever the court's ruling is, but I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what WEAK is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana, for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Massa and Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client, trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being related to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice prong. So, but yes, if these things could ever arise to ineffective assistance of counsel and justices, I'm not conceding that, but if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible.
All right. Ladies and gentlemen, this courtroom will be exited in the closing match. So, first 3 rows on either side of the courtroom.
Oh, great. Now I have to go back on camera. Hello. Yeah, so I had trouble focusing on what just happened. So I'm going to have to watch it again after this live chat ends. So what are you guys thinking? I just did a quick poll. Do you think Judge Gull should be removed? Should Baldwin and Rosie come back? There were a lot of good points on both halves, the attorneys and also the justices of the Indiana Supreme Court. I don't know. I don't know what they're going to decide. Hopefully within the next 2 weeks or so, they should issue a written response to this. At this point, honestly, I'm just like, if Rick wants Baldwin and Rosie, then it should be Baldwin and Rosie. Get this over with in 70 days. However, as one of the justices said, what happens if Rick is found guilty? Is he going to say, oh, well, Baldwin and Rosie were incompetent and that's why I was found guilty? Hi, Randy. Gull should stay and his old lawyers should go. I don't know. There's so many different opinions. So hopefully you guys will be polite to each other in chat. Hi, Big Fish, Small Pond. The judges went hard on both sides. Yeah, I didn't think they were necessarily biased against either side of the arguments. Hi, Susie. Counsel for state were not strong enough. So Gutwein and Sanchez. So, Sanchez, I think, she works at Todd Rokita's Attorney General's office. Trish makes a good point. Justice for Libby and Abby has to include justice for all. Any conviction needs to be solid and appeal proof. However, I mean, Sanchez made a good point. How aware is Rick of everything that Baldwin and Rosie did? I mean, Rosie could walk into the prison and meet with Rick and say, oh, they want to get rid of us. Here, sign this letter. But does he know, I don't know, everything that's been going on? I don't know. Oops. JM says, if they have to start over, so be it. You can't control everything. I don't know. I mean, the one Gutwein was saying there's other avenues other than having the Supreme Court make this decision. Hi, Clee. Nothing was brought up nor argued about removing Judge Gull. Yeah, I think some people are wondering how likely are judges to agree to remove a judge. Son of Liberty, I was referring to the fact that he stated repeatedly that the action taken by Gull was a first. If it's a first, he would be undermining his own argument by citing precedents. Yeah, I didn't understand some of these cases. Obviously, we kept hearing the word wheat, which was a prior case that he was referencing. Also, there's something about Strickland. I have no idea about legal stuff, so I'm not sure exactly what that was about. Hi, hippie. She did nothing wrong, Gull. Why peeps want to free Richard Allen is very curious and curiouser. Lots of different opinions. A lot of people think Rick is innocent. Some people think he's guilty. As I've said, I just want the full evidence to be provided at the trial so the jury can make a informed decision. Because if Rick is wrongly convicted, that solves absolutely nothing. Shelley says, I think the judges are going to grant everything that Rick's attorneys asked for. So Gull goes bye-bye, Baldwin and Rosie come back. I think as was mentioned, the Chief Justice said, why did Baldwin and Rosie not file this 70-day request for a speedy trial, which Mark Lehman's response was kind of interesting to me. Didn't he say, because it was less than 70 days? I don't know. The trial was supposed to start January 8th. So was there some kind of deadline related to that start date where they could not file the 70-day request until a certain day? I don't know. But people have said, well, they had Rick sign it in August. They could have filed it at any time, but they did not. Hi, Mommy Wolverine. Hi, SB74. Most guilty verdicts are appealed. Yeah, in Rick's letter, he said he wants Baldwin and Rosie to represent him. Essentially, he said, no matter, however, the verdict, whatever the verdict is, guilty or innocent. He did not say guilty or innocent, but he didn't say, like, I want them to prove I'm innocent. I don't know. Big fish, small pond. Yes, they should. No matter what, if he's found guilty, he'll appeal for something. That's his right. Basically, any murder case will be appealed. I don't know. Is he hoping, if he is truly guilty, is he saying, okay, let me try at least once to be found not guilty? Hi, T-Bone. The judges already had their minds made up reinstating Rick's defense. I don't know. I do hope that they have spent a fair amount of time preparing for today so that this written opinion will come out fairly quick. The Chief Justice seemed to be like, can we just like find a way to get this case moving forward, which was a good sign. Hi, caricature contest. Part of me thinks just start over. New judge, new jury, no prejudices. Yeah, I mean, I think some people are overly critical of Gull, but I have no reason to like say, oh, she has to be the judge. So if they want to assign a new special judge, I'm fine with that. Just get it going. Sidonia Plain. Rick should never waive his right to appeal. He could lose for reasons outside of the arguments today. Danielle, I think she has a legal background. The point made about the Wheat case being about conflict of interest was pretty strong, in my opinion. Well, I believe the conflict of interest was based on Rosie filed a notice of tort a few months ago, which is basically saying at some point we, I guess as Baldwin and Rosie, might file a civil claim, which would entitle Rick and the attorneys to maybe a decent amount of money based on Rick being held at Westville, which he's supposed to be at a county jail, but that's a whole nother issue. So I think that main conflict of interest, is that what we're talking about, the tort claim, which was one of Gull's concerns about are Rosie and Baldwin only wanting to continue to represent Rick as public defenders because after he's maybe found innocent, they will be able to file a civil claim and make millions of dollars. Danielle says, based on the arguments, I still feel Judge Gull should be removed, and in the interest of justice and law, his attorneys be allowed to represent him. I'm okay with it, with that happening, although I would not hire Baldwin and Rosie. T-Bone, removing Gull will go hand in hand when the defense is reinstated. She will be removed. Well, can you imagine what's going to happen if Gull stays and Baldwin and Rosie come back? I don't know. My main concern is that this is just going to be a few more months of going back and forth. Should Baldwin and Rosie stay in various hearings? And it's like, just let's get to the trial. Hi, Loopsy Loo. I don't get it. How can there even be a decision without showing what Gull believed was incompetent? Like, what if they really were and there was no more to it? He would just be thrown those same lawyers. I'm not sure if you're talking about just because they did not bring up certain points in today's arguments, the 5 chief justices of the Supreme Court have all these various supporting documents. I thought that Mark Lehman made a good point, even though I do think Baldwin and Rosie have shown signs of incompetence. Did it show that it would affect their ability to represent Rick in the courtroom and to show whether or not he is innocent or guilty or to defend him? I don't know. Yeah, I agree, SP 74. I'm still confused as to why the defense was going to demand a speedy trial when it was already scheduled for January 8th, which was like less than 3 months, like that's a 20-day difference between whatever, like mid-October to mid-January. That didn't sound right, but you know what I mean, hopefully. Charmaine, every justice said in different terms, quote, what's the harm in judge doing things the proper way? I mean, Taylor says they should keep the judge and let Rosie and Baldwin come back, then allow Gull to have her hearing that was planned in public court. I know, but as was stated, how are Baldwin and Rosie going to convince her that her concerns previously have changed, like that they're more competent than they were previously? And as McClelland said, I mean, Baldwin, obviously typing an email to somebody and it autofills, that's something that a lot of us have done. However, I mean, it was kind of like the worst possible scenario that Baldwin sent it to Brandon Woodhouse, who hates McClelland and Carroll County Sheriff. What Baldwin sent ended up on Facebook. Baldwin, I agree that he's not necessarily guilty of anything for Mitch Westerman going into his conference room and taking pictures of Abby and Libby, which then went from one person to another. However, I mean, I do have some issues with why was Westerman even there? He's a former employee, and there's been rumors that Westerman was helping Baldwin, but there was a prior motion. I guess McClelland filed something about protecting discovery evidence. And one of the points was anybody who helps the defense has to sign some kind of agreement that is filed with Judge Gull. So was Westerman officially helping the defense? Did he sign an agreement that Baldwin submitted to Gull? Also, the guy who committed suicide, who Westerman had sent the photo to, he made some online comments that he was also helping the defense try and like poke holes in their onus theory or various other stuff. So did Baldwin have him also sign an agreement that was submitted with the court? If not, is that a bad sign of Baldwin following the process, which obviously I'm saying it, so I do think it's bad. I don't know if they were signed, those agreements were signed or not. AS, wanting a fair trial is not wanting Rick to be free. Yeah, I want Rick to have a fair trial and have the best possible attorneys. I just have concerns about Baldwin and Rosie overall. But if that's what he wants, then he's the one who's going to have to deal with the consequences of the sentence if he is found guilty, which at this point, I've come to expect the unexpected in this case. And I'm not expecting a guilty verdict, if I'm being honest. I just don't see this having a resolution because it's just been one thing after another where nothing really goes according to a proper resolution. Hi, KT. Gull really made a mess of the process. Whether he's guilty or innocent has nothing to do with Gull's complete disregard for proper procedure. I agree that there should have been at least some kind of greater perspective given to Baldwin and Rosie about what was going to be presented at the October 19th hearing. No scrubs. TLC is in the house. I wouldn't want Baldwin and Rosie as my counsel in such a serious matter. They always have an excuse like a 10-year-old. Yeah, so for people who are at work now, unfortunately, I'm doing more live chats later today. I'm doing a member live chat at 4:30 Pacific, 7:30 p.m. Eastern, and then an hour later, I'm going to do a public live chat, 5:30 p.m. Pacific, 8:30 Eastern. If you're in Europe, turn off notifications so I don't wake you up. Yeah, so I might replay that hour-long hearing again, and then just discuss with people who couldn't join earlier today. Hi, Big Bird. I think we're going to get an answer very fast. Yeah, but what is that going to lead to? Even more drama and hearings? Big Fish says, he said they were filing it right after deadline for discovery. So deadline for discovery was November 1st, correct? So Baldwin and Rosie were preparing to submit the 70-day request, which would have been January 10th, right? When the trial was supposed to happen at January 8th, which some people were saying they weren't even expecting it to happen January 8th because the defense would have kept filing different motions to hopefully not even have a trial. Obviously, we know that we're waiting for Gull to make a decision on quite a few different things. One of the most important ones was a Franks hearing or not. I think she's currently on page 21 of the Franks hearing. She still hasn't gotten to finishing it. Hi, Faye. I think we are all afraid Rick is guilty and these lawyers might just get him off. Well, some people think he's innocent, but I agree. My greatest concern, or I have two concerns. One is Rick is guilty, and for some technical reason or the jury doesn't believe certain evidence that's presented, he is not held accountable. My other concern is if Rick is innocent, that means this case is like totally cold and there might never be a resolution. I'm not frozen. I'm just looking for comments. Kay says Gull's opinion was reasonable, but her actions were not. The fact that process was not adhered to is going to come back to bite her and the state. That's a good point. Mommy Wolverine, are they on lunch recess? I wish I was on lunch recess right now. No, it was a 60-minute hearing. They will go, I guess, discuss. I don't know what the process is. I tried to get 4 former Indiana Supreme Court justices to join my live chat today, and 3 of them replied that they're currently special judges, so they should not be publicly commenting. So I tried to get some more, like, whatever, figure out what's going on behind the scenes, but unfortunately I don't know. So hopefully their written decision will come within the next few weeks. Jacqueline says, I think Rick is likely guilty, but don't object to him. Sorry, my microphone's far away. But don't object to him getting his old attorneys back. If that crazy conspiracy is the best they got, they'll be lucky to not get laughed out of court. So you're referring to the Odinist conducting a ritualistic sacrifice of white girls killed Abby and Libby. And if you were watching before, the third party guilt reference, like the strategy of the defense, that is, I think what they're referring to is Rick is innocent and the third party who is guilty is these Odinists. Which, I mean, I don't know. I mean, if the defense tries to present that, which also the 2 new attorneys seem to be referencing Odinism as a possible connection, what happens if McClelland and whatever Holman gets on the stand and says, okay, well, Odinist number 1 we cleared him this way, onus 2, 3, 4, 5, that whole list that was in the Franks memo of who were accused. And again, just a reminder, it was not Baldwin and Rosie who came up with that theory. It was Ferenczi, Murphy, and Click, who were near Rushville, law enforcement officers. They came up with this report. But my concern about that is, did those 3 officers who said, okay, onus were probably responsible, did they have access to all this other evidence about like alibis and other stuff like that for those guys, the onus guys? Good morning, Kevin. My feeling is that the judges want this trial process going back on track sooner than later. I think they'll reinstate Baldwin and Rosie. Yeah, it seemed like at least the Chief Justice said at least twice, how can we get this case on the track again? Anne, hi Anne. If Gull is reversed on her original decision, I sure hope, so Baldwin and Rosie come back. I sure hope she now holds a full public hearing about grounds for Rosie and Baldwin's dismissal. That would be very interesting, especially the photo gate, the leaks of the crime scene photos. Yeah, because, well, McClelland, he said, I think in the October 19th chambers, it's not just a one-time photo leak. McClelland was going to present witnesses and exhibits showing there was an ongoing leak by the defense. Was that one of the reasons that Baldwin was like, yeah, I'm not going out there. I'm going out. Where's the back door? I mean, I understand that they wouldn't want to go out there unprepared, Baldwin and Rosie. So I don't know. As I said before, my concern is that, is there now going to be a hearing that's going to take 2 months to schedule for Baldwin and Rosie to say we're competent, and for McClelland and the state to say you're not, you were doing ongoing leaks that prevented Rick from being represented properly or tainting the jury pool? Shelley says, why aren't they realizing that Richard Allen could appeal incompetence of defense with the new lawyers? So you're saying if Baldwin and Rosie are not reinstated and Rick has to go through trial with Labrato and Scremin, and then he's found guilty, is Rick going to appeal saying Labrato and Scremin were incompetent and I wanted Baldwin and Rosie, who could have had me found innocent? Clee, I was there on October 31st. So October 31st was the hearing where Gull essentially said, Baldwin and Rosie, I don't care if you want to represent Rick for free. I still find you incompetent, and I'm trying to look out for Rick's best interest. It was very evident that the state was ready to present a case. It again was evident that those ready to testify for the state knew nothing about what Judge Gull had planned to do. So wasn't Doug Carter there? I know Holman was there. Various other police officers were ready to testify about these photo leaks, which I don't know what the purpose of that was going to be. Was it for McClelland to show, I don't know, that Baldwin and Rosie should be disqualified? It seemed like that was what it was going for. Hi, Lala. Lala says, the Odin defense has passed its due date. Well, back in August, I guess Holman found out that the defense was going to be presenting this whatever third-party guilt, saying that the Odinists were the true killers. And it seems like at least some of those quote-unquote Odinists were called back in to be interviewed by Indiana State Police. So August, I don't know, like 4 months ago, 5 months ago, Indiana State Police took another look into these guys, and as we know, nobody else has been arrested, either an Odinist or somebody helping Rick if he is bridge guy. I don't know. Some people think it's a conspiracy that the Odinists are guilty, and even if McClelland and the state found evidence, they have something against Rick that they can't admit that they wrongly arrested him. I don't know. Hi, Venus Gal. Should I read this with some sarcasm? If only Rick knew he'd be better off with saner, smarter, ethical attorneys, of course they aren't going to tell him that. What? Are you saying that Rosie wouldn't tell Rick on October 11th, you're better off with other people, don't sign this letter saying you want me to continue? I don't know. Kay says, if I had to bet, I'd say they rule in favor of Baldwin and Rosie, even though I agree with Gull that they probably should have been removed. Attorney General was hamstrung by an incomplete record. KT, Gull was exacerbated with the defense team. Again, whether he's guilty or innocent, the legal process has to be followed, and Gull let her reactions and judgy status drive her actions. Hi, Annie. Yeah, if you guys are at work, I'm doing another live chat later tonight if you want to come back later. I don't know, how long have we been doing this? So we're at 1 hour and 59 minutes. I've been doing 2 hour and 59-minute live chats for a while, so maybe I'll go another hour. We'll see. I'm only 13 minutes behind comments. Venus Gal, there were a lot of questions regarding the right of the trial judge and discretion. Baldwin and Rosie are scum, okay? Some people love them, some people don't. Apparently Rick is a fan of Baldwin and Rosie, a fanboy. Anne says, I heard one of the judges say that Rick wants to invoke his right to speedy trial now. That's interesting. Could see an earlier trial date, but I don't think defense really wants that. Well, currently it's, I think, October 15th, which like 10 minus 1 is 9 months away. I don't know. It's just crazy to me that this trial should be happening right now. Kevin says, I don't think any of us want to go before a judge that can use her discretion to remove our attorney of choice. But what is her responsibility to make sure that Rick is getting the best defense? I don't know. Danielle, if Gull stays on, I would think they would be an increased risk of appeal based on decisions she might make during the trial. I don't know what the right answer is, but we obviously want a resolution to this case. Rick should have the best defense if he is innocent or even if he is guilty. I don't know. If Rick says he wants them as his attorneys, then I say, fine, make them his attorneys and he'll have to deal with the consequences. Hi, Bren. It's darned if you do, darned if you don't, i.e. he can up. Oh, no. L-E or I-E? Sorry. He can up IA of counsel. Either way, not to mention lack of a speedy trial. Sorry, I didn't understand some of those abbreviations. Mommy Wolverine, Rick doesn't behave like an innocent man. Well, some people say, how does an innocent man behave? Although I have said this previously, if I had been on the trails noon to 1:30, and this is a huge either misunderstanding or a false arrest, which I don't believe, people say the term patsy, which is essentially saying Rick was falsely arrested by police and the prosecutor knowing he was not guilty, which to me, that does not add up. Like, so I'll talk about this for 1 minute. The thought that Rick was a patsy because Tony Liggett wanted to become sheriff. So Lesenby had been the sheriff for a while. The election was in November. I don't know, I've seen various conspiracy theories about this, but I've never seen anybody specifically show evidence or like something that made sense. So I guess people are saying like Liggett wanted to be sheriff, and I agree that his salary increased over $40,000 a year. So yes, that's a great incentive for somebody to want to be a sheriff. But I don't think that Liggett came up with this grand plan. I'm going to arrest anybody a few weeks before the election. So everybody in Carroll County is like, oh, Tony Liggett's so great. I'm going to vote for him as sheriff so he can get this $40,000 raise. I would not have voted for Tony Liggett in whatever, early November, when I was reminded on October 28th, it took him 5.5 years to arrest somebody who lived in town and who worked 1 block from where Liggett worked. And my main concern about this patsy accusation, I mean, so what would happen if Rick was arrested as a patsy? They had no idea what they were going to find on October 13th at Rick's house. So what if Rick was there on the trails noon to 1:30 after he went to lunch, which I've said previously, I really want to know where and when Rick ate lunch that day, because I don't know, that's a whole nother issue. So police did not know if Rick if he left the trail at 1:30, there's a McDonald's right next to CVS. On his way home, did he say, I need a Big Mac? Law enforcement would not have known if Rick had a credit card receipt that he was going to produce a week after his arrest saying, I told my wife knows I was at home by 1:45. I went to the trails, I went to McDonald's, and I went home. She called my credit card company and they got the receipt showing my Richard M. Allen credit card bought a Big Mac at 1:37 p.m. on the day of the murders. I was not at the trails. Police had no idea that Rick could be able to produce evidence like that to prove his guilt, or sorry, to prove his innocence. Also, as I've shown previously in my evidence against Richard Allen video, computer data on cars are very detailed. Because of the 5.5-year difference between the crime and confiscating Rick's car, I don't know that data is still available. But law enforcement didn't know if they were going to get that car data, and it would show Rick, whatever, started his car at 11:52 a.m., parked at CPS, turned it off at 11:58. The car data then shows he started it at 1:30, whatever, drove to McDonald's or drove home. Law enforcement didn't know that. So you really think they're going to arrest Rick falsely just so like Tony Liggett can get a raise? That doesn't make sense to me. And Tony Liggett was not the only person responsible for arresting Rick. There are other people on the Unified Command who had to review this evidence, and McClelland had to feel like he would get have enough evidence to get a guilty verdict. So that whole patsy thing does not add up to me. And also, yeah, as I started saying 5 minutes ago, we have not heard a peep from Rick. I don't know. Would you act the way Rick has acted in various aspects if you were falsely accused of doing this? I would not have. Would you call your wife and your mother and repeatedly say, I killed Abby and Libby? I wouldn't. I know there's been debate about his mental health, but I mean, this is something else I've also brought up. Rosie and Baldwin say, Rosie at the June 15th hearing said, we've only spent our time for the past however many months since November 14th when they were assigned trying to get Rick out of Westville. That's not true. They didn't file until April 5th, 2 days after Rick called his wife and made incriminating statements. So all those months, they actually even said in a filing, Rick was fine mentally for 5 months until early April. So what happened? The warden at the June 15th hearing said Rick started acting cray-cray after he got legal paperwork. And I've said that it's really just suspicious to me as I try and figure out, is Rick innocent or guilty? And I've not come up with the final decision yet. He's fine for 5 months. April 3rd, the intern and the private investigator for the defense go to Westville. I guess they brought Rick legal paper and evidence or whatever. I don't know that his phone call to his wife and mother was before or after this meeting on the 3rd with the defense team. But if we're shown in court as a jury, here's Rick. He's acting okay in the morning on April 3rd in his cell. He comes back with these papers in his cell that the defense team showed him. He's like reading through a few of them. If he truly is guilty, did he read something on those papers and says, oh crap, they have evidence that I cannot, there's no way I can explain this away. I'm going to be found guilty. Picks up the tablet, calls his wife and says, what does he say? I don't know. So hearing this phone call and also seeing the video from Rick's cell, which is under 24-hour surveillance of video only, not audio microphone. But I'm sure they're going to be able to sync up the video and this phone call for the jury. So is Rick crying on this phone call, like essentially saying to his wife, I did this? Is he like, is his tone of voice revealing this secret that he's kept for whatever, 5.5 to 6 years? I don't know. It doesn't sound good to me to point towards Rick is actually innocent. Hi, wishful thinking. If they are so incompetent, how are they still practicing? I don't know. There's different levels of incompetence, I guess. And as Mark Lehman pointed out, were Judge Gull's concerns a reflection on how well Baldwin and Rosie could represent Rick during the actual trial? Big Fish says insubordinate does not equal incompetent. Was that one of the quotes from Lehman or something? My stomach is growling. I'm hungry. Hopefully my microphone did not pick up my stomach growling. How much more time? 50 more minutes. Again, if you're just joining, I'm doing another live chat tonight at 5:30 Pacific, 8:30 Eastern. If you're at work right now, want to come back later. Ann says to Kevin, judges have a responsibility to dismiss counsel for a good cause, like professional malfeasance, such as the Photogate scandal in this case. Yeah, I understand that. But also, as I said before, how much did Baldwin have to do with that those photos getting leaked? It wasn't, he didn't do it directly, although McClellan was going to talk about an ongoing leak. So what was going to be presented October 19th that would possibly make Baldwin and or Rosie look even more incompetent than we've been presented publicly. Matt says, Gull lied when she said there has been an unexpected turn of events on October 19th. If she knew what would happen, she is shady. I partially agree. I would say the unexpected turn of events was maybe she expected Baldwin and Rosie to at least go out into the courtroom and hear this evidence that was going to be presented to show that they were incompetent and responsible for these leaks, which were negatively affecting their ability to represent Rick and for Rick to get a fair trial. Lots of different opinions. KT says incompetence is the wrong word. I'd take Rosie, but not Baldwin. Incompetence is really a stretch. Yeah, I agree that. I don't know. Maybe I don't know. I don't think that Rosie did a perfect job either. I mean, I brought up he was the one who signed that motion to modify safekeeping order with those various accusations against Westville conditions, which the warden at the June 15th hearing, he spoke, and he also submitted an affidavit saying that a lot of those accusations were not true. Although during this hearing an hour ago, the Chief Justice said some of them were not true, which means that some of them were true. I don't know. Charmaine, her concerns are not grounds for removal, said a handful of times by the justices. Venus Gal, I'm not sure if you're talking about Baldwin. Supposedly, it was an accident that he typed BRA to send the index of discovery to Brad Rosie, but he typed out BRA and it autofilled Brandon Woodhouse, who obviously had already exchanged emails with Baldwin as of this was in early November of last year. So Brandon Woodhouse, as I said previously, he's local to Carroll County. He's been arrested quite a few times. He sued the Carroll County Jail in Tobe Lesenby based on the conditions, I guess, that or how they treated him when he was in the jail of Carroll County. And apparently they settled. I don't know if it was like for $35,000 or something. I don't know. So Venus Gal, you think that Baldwin knew what he was doing when he sent that index of discovery items to Woodhouse, and that he would eventually put it on YouTube, which he did? I don't know. Anna says, I think there might be a legal issue in that Rosie and Baldwin are only fired from Rick's case, but allowed to continue other business as usual. The only one harmed is Rick, another year incarcerated. Yeah, I mean, if Rick is innocent, this is horrible for him to have to spend another 9 months at least waiting for this October 15th hearing, and also for his family to find out if he truly is a child murderer. And also the families of Abby and Libby. It's just like it goes on and on and on. Hi, Gen Z Finance. Regardless of the outcome of this trial, I hope someone offers to represent Libby and Abby's family for free against Rick's attorneys for the leak of those pictures. In my opinion, that was 100% their fault. Yeah, I think we have to remember, I mean, it's not just like pictures of a crime scene. Like Libby was nude in these photos, like nude and murdered. It's like, would you want people taking photos of your deceased loved ones like that? And what was Baldwin's responsibility to protect that evidence from being out on that table? I understand that it was out in a conference room at Baldwin's law firm, and it wasn't just like anybody walked off the street with their cell phone and then walked out, and like Baldwin's coworkers weren't like, who is that strange person? But I mean, regardless, the photos were taken and passed around. That's like the outcome is what's more important than exactly what I guess led to it. I don't know. Alex says Sanchez, who is from the Attorney General's office on behalf of Gull, did not help their argument. SP74, I wonder why Gull didn't just sanction Baldwin and Rosie for their shenanigans. Yeah, there's certain other, like, instead of just banning them from the case, she could have like filed, I guess, ethical concerns. Kevin says a judge can find an attorney contempt of court, i.e. for disobeying the gag order, then penalize them. Well, as the Chief Justice pointed out, the gag order was not issued until after the press release by the defense last, like around December 1st. But she said there was an issue where the defense knew this gag order was going to be coming and McClelland was going to be submitting it officially. And in those closed door meetings, I guess late November 2022, Baldwin and Rosie said, we don't want to try this in the media. Yet they put out a press release, and obviously some people argue on the other side of that. Well, the prosecution and the state have had a bunch of press conferences stating their take on the case. Why can't we stick up for our client, Rick, and put this out? my issue with that defense press release was on like page 2, various bullet points were talking about like Mike Thomas, who was the guy who ran against Liggett for sheriff. And he also, I guess, sued Carroll County. Did he sue? I'm not sure. There was like some kind of drama between Mike Thomas and the Carroll County sheriff and Liggett. So I think in that press release, the defense was bringing up, well, this guy is suing Carroll County. The election is coming, or the election just happened. Kind of like saying, oh, Rick was only arrested because of this election drama and maybe Tony Liggett doing this patsy arrest, which, as I said previously, I don't agree with. My other thing was, if Rick truly was on the trails noon to 1:30, why was that not in the initial press release that we're talking about? Wouldn't the first thing that you would say to your attorneys is, I was not even on the trails at the time of the murders. I was there noon to 1:30. And so Baldwin and Rosie were assigned, I think, November 14th. And a month earlier on the 13th, that is what Rick told Liggett. And Mullen, I think, is the other investigator that Rick talked to on October 13th. And Rick said then that he was on the trails noon to 1:30. There's this huge issue. Was that true? Or did previously in 2017, did Rick tell the conservation officer, I was there 1:30 to 3:30? Why did the conservation officer write down in his official report that he was there 1:30 to 3:30? I don't think it's specifically said in that small paragraph in the PCA that Rick said he was there 1:30 to 3:30. It said he was there, or he was on the trails 1:30 to 3:30, which I mean, it was in the whatever 13:30 to 15:30 time standard. But to me, even if these officers who are going around town talking to potential witnesses were told by the unified command, okay, we're looking for people who are on the trails between 1:30 and 3:30. So ask them if they were on the trails 1:30 to 3:30. So Rick meets at the grocery store the conservation officer. We still do not know if that happened before or after the screenshot and the audio go down the hill was released. So this whole issue of, did Rick not know if he was a bridge guy? Did he not know that Libby videotaped him and that would be released? So if you talk to a potential witness and say, were you on the, would you say, what time were you on the trails? What time did you get there? What time did you leave? Or would you start off saying, were you on the trails 1:30 to 3:30? Is Rick just going to say yes, and then the conservation officer moves on to a different topic? I would say, yes, I left at 1:30. So if that was what Rick said, why would the conservation officer write he was there 1:30 to 3:30? I don't know. It seems like there should have been more follow-up in a normal course of conversation between Rick and the conservation officer. As far as we've last heard, that recording has not been found by the conservation officer, which is ridiculous. JMs, I'm not sure how to pronounce your screen name. They weren't supposed to discuss this case with anyone per the gag order. Yeah, I guess I'm pretty far behind now on comments. Yeah, so did Baldwin and Rosie follow proper procedure to make sure everybody signed an agreement and it was filed with Judge Gull if they were talking about the case? Matt says, your concerns with Baldwin and Rosie are regarding the Odinist theories, which the current attorneys are also suggesting. My concerns with Baldwin and Rosie, one of my biggest thing about incompetence is like a basic incompetence, which is from the Franks memo. I understand that two lawyers are not going to write and research the entire Franks memo, the 136-page memorandum. However, only Baldwin and Rosie signed that Frank's memo. So either they wrote the Frank's memo with all of these errors, which people get triggered that I'm concerned about errors, but 20 times they wrote the name of the prosecutor, McClelland. 16 times they got it wrong. On one page, they wrote Liggett 6 times. 3 times they used 2 T's, and 3 times they used 1 T. They referenced the Westville warden, Gallipo, twice in the memo. They spelled it differently twice, and both times they didn't get anywhere near what his how his last name is properly spelled. So either they're incompetent for making all the errors, or like, did they read the entire 136-page memo that other people in their office wrote? Like, how did they not read that and say, here's an error, we need to fix this before we file this? So that's one sign of incompetence, that they did not correct those errors. And the third sign of incompetence is, did they not even read all 136 pages of that? Why are these attorneys filing a major document that they have not even read? I don't know. I know there's some attorneys in here. Do you think that's incompetence, that they would not even read what their paralegals or whatever wrote? To me, I would not want somebody representing me who did not even read the Frank's memo before they submitted it. And did they even submit that to Rick to get his feedback? I need a drink. Don't look. Oh. I want to know how much Rick is participating in his defense. So if you're somebody who's falsely accused of killing these girls and you live in this small town, don't you think that you would be reading all of this evidence? Like, he has nothing better to do, no offense, but he's in his jail cell, or sorry, prison cell. Don't want to misspeak. He's in his cell at least 23 hours a day. Don't you want to know, like, what evidence they have against yourself? I mean, you're the one who's charged. I'm just curious to know, like, how much is Rick taking notes as he's reading through this discovery evidence and then presenting it to his defense attorney saying, yeah, they say this is true, this is not true, and this is why. That's what, as somebody said previously, Rick is not acting like an innocent person. I would be in my jail cell, you know, like creating spreadsheets. No, I'm serious, and not that you people doubt me. How much has Rick been taking notes and saying to his defense attorneys, this does not make sense, it's wrong, I want you to bring this up at my trial to prove that I'm innocent and falsely accused? I don't know. Is he not reading all this discovery because he knows the answers, because he truly is guilty? I don't know that we'll ever get that answer, other than maybe the video surveillance of his cell showing he's never looking at the papers that he's given. Just one other point that popped into my mind that you guys might not be aware of. So April 3rd was when the defense intern and investigator went to Westville to meet with Rick and presumably present him with these papers, which there's this whole other issue of Rick wetting the paper and eating the evidence papers. I don't know what to say about that. But what am I saying? I'm saying, so April 3rd, they supposedly brought Rick evidence. I looked at the discovery motions with the deadline, or actually it might have been, I don't know if it was that or like a follow-up to the Frank's memo, talking about the discovery that the prosecution has given to the defense. And from the timeline listed, before April 3rd, the last time the defense was given discovery evidence was February. So I'm just curious, like, I don't know, some of the lawyers might be able to give some more context to this. Why would it take over 1 month for them to give that evidence to Rick? I'm not saying there's anything shady, but I don't know. And I do have this whole other issue with the prosecution and the state taking so long to even provide the evidence to the defense. So some people accuse me of working with the prosecution. That's not true. Pushing a narrative. My only narrative is I want Bridge Guy identified and held accountable. And so I have criticized the prosecution and the state for a total lack of organization with this evidence. I've said that previously. I'm not going to keep rambling. Sorry. Shelley says, if the Indiana Supreme Court, thank you for not writing SCOIN, sides with Gull, then that sets a precedent, especially for Indiana, culminating in lots of judges stripping defendants of their counsel. That's a good point. So that's something that the Supreme Court is going to have to decide when they're making a final decision. Hi, Corgi Mama. I appreciate that it was very interesting to view this procedure. Yeah, that was good that they do show those hearings online. Yeah, Big Fish is a big fan of Baldwin and Rosie. I would want them as my attorneys. They clearly were working hard on this case. Sidonia says, ultimately, if Baldwin and Rosie return, Gull has to be removed. Otherwise, it could certainly be argued that Gull is being biased unfair. Once the trial begins, Baldwin and Rosie could say this at any time. Some people have brought that up, that Gull is biased against the defense and she's like pro-prosecution. But twice, McClelland requested Westville medical and mental health records, and both times, including last September, Gull denied McClelland's request. So if she's so pro-prosecution, why would she not be just giving everything to the prosecution? I was going to do a spreadsheet listing all of the times that Gull has ruled for or against each side to show and to learn myself how biased could she be against the prosecution. But I didn't feel like doing it, so it was too time consuming. Gen X Rando, thank you so much. Go get some Taco Bell. I said a few weeks ago, the only Christmas present I got was a $15 gift card to Taco Bell from one of my nephews, and I did have Taco Bell last weekend. So thank you so much, Gen X Rando. I always appreciate your showing up and your generosity. Thank you. How far behind am I? 40 minutes behind on comments, exactly 30 more minutes to this live chat. I'm not kidding. Then I'm going to go back and watch the hearing because I was not focusing at all. Hi, AS. I still have a hard time understanding how the girls texted with Kegan Kline, went there to meet him, but that pedophile didn't come. Instead, Rick came with a gun and a knife. There's a debate about whether or not this supposed quote by Anthony Schatz was, I was supposed to meet them, or I was supposed to meet her, Libby, but she did not show up. I don't know. There's still questions about Kegan and his father, which, excuse me. It's been how many years now? It'll be 7 years. Oh my gosh, really? Wait. Yeah, 7 years. February 13th. Police raided the client's house February 25th, 2017. Neither one has ever been charged with Delphi. So I don't know. The state of Indiana doesn't think they were involved. Obviously, there was this huge issue with the Wabash River search and all that other stuff, but nothing has panned out. Hi, Katja. Hopefully I pronounced that right. How long is it going to be before the Supreme Court will issue a ruling? I only looked at one other oral argument online to prepare for this today. The Supreme Court issued their written decision about 10 days after the initial argument. Hi, Marshy. Thank you. I appreciate it. I think that's the first time I've ever seen your screen name, so run away while you can. Kevin, I know Kevin. Gull should have fined the defense for their mistakes, not disqualify them. Then this case would be in trial now. I don't know. Hi, Jim. Judge Gull is one fine judge. Yeah, some people hate her, some people love her. I'm fine with her being replaced. I mean, I just want this to be wrapped up, to be honest. Jim hopes the Supreme Court takes it under advisement for a year or two. That's not good, especially if Rick is innocent. He does not deserve to be in a cell for another year or two, which honestly, some of these cases take so long to go to trial. We might be delusional thinking that it's even going to happen next October. I don't know. Perish the thought. Oh my God. Hi, Jennifer. Thank you. I appreciate it. Don't watch that. Oh my gosh. Where did you see that? Next topic. But thank you so much, Jennifer. I really appreciate your generosity and laughing at me. Wishful thinking, maybe cut Baldwin and keep the better of his current assigned attorneys and do it all under Gull. I don't know. It's going to be interesting to see. Yeah. So when is my next live chat other than tonight at 8:30 Eastern? Whenever this written decision comes out, I'll probably do a live chat the same day and the same night. Susan makes a good point. And yet Abby and Libby lie in their graves and the circus just continues, which, I mean, I do understand your point, but at the same time, we do need a fair judge, a fair trial for Rick and for the girls, and fair representation for Rick. So what is happening now does matter to the eventual outcome. KT, you really think the defense was intentionally leaking information? Color me surprised. I don't think I've ever said that I thought that they were, because I don't really see how that would benefit them. I don't know, maybe I misspoke previously, but I do not think that Baldwin and Rosie were intentionally leaking the index to Brandon Woodhouse or intentionally leaking the crime scene photos. However, McClelland said he was going to present that there was an ongoing leak by the defense. And was he going to say there was a certain reason for it? I don't know. Just one other issue. Some people have said just this whole circus of the defense and this leaked photo, which luckily has not really ended up online or like on the internet. I've not seen them. I don't want to see them. Some people have said it's tainting the jury pool, but from my experience, like with my mom, like she's never been on the internet. So obviously people in Indiana have access to the TV and the news station, so they are somewhat familiar with at least the basics of this case. But there's going to be at least 12 people they can find who do not know all these details, like everybody here in this chat right now. Big Fish, the Supreme Court seemed to say they would rule on the merits of the dismissal, and if Rosie and Baldwin are reinstated, the trial will be in 70 days, or the charges have to be dropped. I must have missed that part. Caricature contest. Part of me thinks Baldwin and Rosie decided to throw some curveballs, get us to look over there. Meanwhile, Rick is here admitting to killing Abby and Libby and eating paper. I agree. That's a very good point. I think they absolutely, Baldwin and Rosie must have freaked out when they were informed your client just called his wife and admitted several times that he killed Abby and Libby. In the, what was it? It was some kind of document. I think it was the Franks memo. It said, I don't know. So April 3rd is when the intern and the investigator met Rick at Westville. Then he made the phone call. The following day, the 4th, Baldwin and Rosie showed up to Westville, and they said that Rick was incoherent, acting schizophrenic and delusional. So you make a good point. It's like, as a lawyer, when your client admits to his family I don't want to say from the comfort of his cell, but it's not like he was being grilled for 8 hours by police officers. He picked up his tablet and said, I'm calling my wife. What was his motivation to dial his wife's phone number and say, I killed Abby and Libby? Like, what mental condition would cause somebody who had been okay for the previous 5 months to like start admitting to being a child murderer to their wife and their mother when they're not a child murderer? Why would he lie about being a child murderer to his family? I don't know. As a jury member, that's not good for Rick. Kevin makes a good point. The fact that the new attorneys are also citing Odinism to me suggests there is more undisclosed evidence of this. It's too far-fetched otherwise. I don't know. Hi, Hooky Bricks. Hooky. DNA King is a defense attorney. I don't know that he wants to be on camera or voice either. Hi, Jane from the country, as opposed to the suburbs. Rick Allen should have his choice of lawyers. Bring them back, his original attorneys, Baldwin and Rosie. 20 more minutes left of this live chat. L.A. Brandt, Gull out, Rosie back, maybe Baldwin with sanction. Yeah, that'll be interesting to see if they allow Rosie, but not Baldwin. I don't know that the Supreme Court would say one or the other, though. I don't know. Danielle says the Odin theories came from the FBI task force members, not Baldwin and Rosie. However, the FBI and law enforcement did not accuse the two guards of like threatening Rick, saying, call your wife and confess or else your family's going to be killed. Like that was the defense team, Baldwin and Rosie, who signed that, who I felt they overstepped by like falsely accusing these two guards at Westville of doing stuff that's inappropriate. I know that the new attorneys have also said that when those two guards at Westville would come to Rick and say, do you want your shower or rec time? They would go like this, indicating and intimidating him, like, we don't feel like wasting our time taking you there, so you should say no, so we don't have to. I don't know. As I've said previously, Rick's cell is on constant video surveillance. So does the defense have video where as these guards come up to Rick to ask him, does he want to go take a shower or some rec time? Are they intimidating him by moving their heads back and forth? In my previous live chat, I said, if I was with Rick, I wouldn't care if they were moving their heads back and forth. I would say, I want my shower. Tough. That's your job. Take me to rec time or my shower. And somebody commented underneath, like, you with your Todd Chrisley looking ass would get beat up by the guards if you told them that. But if he's entitled to rec time in a shower, then take it. Why is he saying, oh, I'm scared to go against the guards? Somebody said, oh, they would have beaten him up. How's he going to get beat up for saying, yes, I want my shower, take me? I disagree with that part. And then I look like Todd Chrisley's ass. If you don't know who Todd Chrisley is, consider yourself lucky. All right, next. AS keeps bringing up the West Memphis 3. I'm not familiar with that, so I can't comment. JMs, if it was Odin theory, someone would have been arrested by now. I agree. I mean, the only thing that came out of this Frank's memo, I don't want to say the only thing, but one good thing is that if law enforcement truly did not properly look into these Odinists back in 2017, which, as far as I remember, they were still looking into some of them and interviewing their siblings and stuff as maybe late as 2020. Hopefully they've gone back. I know that at least one of the Odinists the guy PW is his initials. He said he was grilled for 4 hours, and by grilled I mean interviewed, back in August of this year. So law enforcement, I don't know, maybe they're going to arrest an Odinist, but it hasn't happened by now. Hi, Kay. Music Taylor. Nice to see you. Just plug your ears. The defense attorneys lie, lie, lie. Well, as I was just thinking, as I was reading that about the Odinist, they, in the Franks memo, they said this PW guy who's 6'5" or so, they said there was this video of this pagan ceremony, and they said PW is reaching around the same area of the F tree, which had Libby's blood supposedly written in the letter F at the crime scene. In the Franks memo, they said in this video, PW is reaching the same area where the F tree was written. So insinuating that he was doing something at this pagan pride ceremony that would indicate he could have done the same thing, marking a tree at the crime scene. In reality, I mean, they looked at this video. You can see this guy, he's reaching as far as he can. He's 6'5", reaching up to approximately 8 feet. Later in the memo, the defense said the F tree was about 4 feet. So to me, that was one of the things that turned me off to the defense, is like, I mean, you can call it a lie or stretching the truth, but that was not true. So it's like, why would the defense even say that? Obviously, they're looking to take blame away from Rick. Hi, Stacy's mom. Baldwin and Rosie are toast. Wheat? Get it? Anyway, you had to be here before. Especially since they enabled the leak. I don't know. Baldwin was supposedly in his office with the door closed when Westerman did that stuff, so he did not necessarily know what was going on. Gen Z Finance, the onus theory might have merit, but I think a good prosecution will be able to dismantle it / highlight how crazy it sounds. Like, yeah, it's like a ritualistic sacrifice of 2 white girls by white supremacists. Makes no sense to me. As a potential jury member, I mean, I'm not really buying that. And if the defense presents it, how quickly can the prosecution prove that those 5 guys were elsewhere? It's a big ask for a jury to believe, and a reasonable voice can fight it. 14 more minutes. All right, I'm way far behind. Let me skip some comments. Sorry, people. Uh-oh, Basia doesn't like me. Am I the only one weirded out by Tom always calling Alan Rick like he was a friend or something? Rick's wife, I just triggered Basia. His wife posted on Facebook calling him Ricky. From what I've seen, people in his day-to-day life and at work called him Rick. So I know like people get triggered when people call Gull or call Judge Gull. I don't know. At some point, I changed to calling Rick by his last name, since I call everybody else by their last name. But people got confused, like, who is Alan? So sorry, I'm just going with Rick. SP74 makes a good point. Odinists signed their work with almost runes, but don't want credit. Yeah, so it's like you are a white supremacist who kills 2 white girls, and you leave the branches on Abby and Libby in shapes of these runes that only, or not only, but that are associated with Odinists, like saying to police, okay, you found these 2 girls murdered. Make sure you look into Odinists first. It makes no sense to me. I don't know, I could be wrong. I'm often wrong, but as a jury member, as I said, that really does not make sense. And how do we know that even if those are Odinist symbols that were trying to be formed with the branches and sticks, how do we know that Rick was not aware of some Odinist symbols and trying to like deflect the real motive, which was maybe sexual and not a ritual for Odinists? JM's, we have heard Brian Koberger's voice. Why not Rick's? Maybe because he's bridge guy. I don't know. Shelley says, it's not crazy, the Odinist theory. The FBI said if Odinists weren't the murders, at least the scene was that of Odinism. So number 1, Purdue professor. Number 2, 3 state cops. Number 3, FBI behavioral analyst unit. Fact, sorry, got cut off. I mentioned this previously, and I said that one of my issues with the Purdue professor, he said it was, hopefully I'll get this right, it was obvious that these branches on the bodies were someone trying to replicate Germanic runic script, which are basically like these symbols of stuff related to Odinism. However, he was re-interviewed by Holman September 19th of last year. He said he could not interpret, he said he couldn't interpret, I guess, the runes. So as a jury member, how are you going to convince me that Odinists left some kind of message if the professor cannot say what it meant? Somebody said, I said, well, if the professor cannot interpret, like on Libby, I think Abby, there were 3 branches, Libby, there were 4. So if the professor at trial cannot say, okay, on Abby, these 3 branches, as you can see, they're in this shape. Here is the shape of this specific rune name. So on Abby, that's that rune. You can see it matches up. The message there is like, this is what this rune means. Same thing for Libby, and same thing for the F tree, which there's debate about even in this runes, like the traditional F, the horizontal lines, the 2 go straight across. As runes, there's 2 different symbols. One, the lines go up, the other, the lines go down. So somebody said, okay, maybe the professor said, yes, these are the runes, but I can't interpret why they were left there and which exact message the killer was trying to convey. So we're going to have to wait, I guess, to get that clarification at the trial, if the Odinist theory is even brought up. Sorry. Yeah, we have 9 more minutes, and I'm out of my misery for at least a few more hours. Hi, Naperville, Susan. I feel like the original attorneys will be reinstated. Their attorney's presentation was solid. I think the judge will remain. The Supreme Court will probably just say, go forward with the status quo. Well, how is Gull going to feel having to deal with lawyers that she feels incompetent? Like, there's going to be massive amounts of conflict between Gull, Baldwin, and Rosie. Let's see, what have we not talked about? Hi, wife Lilith. He probably had paper that day, considering that's his meal of choice when he's like that. Yeah, it's going to be interesting to see. I don't know. Does anybody know? I know there's a few attorneys in here. So this April 3rd is like a huge day in this case, even though it happened after the crime. Can the intern and the investigator who met with Rick on April 3rd be called to testify at the trial to say what they presented Rick with on April 3rd before he made this confession phone call? What evidence was he given? And so can the prosecutor say, Rick was given a specific document on April 3rd that was maybe at the top of the pile. That evidence was this. Rick freaked out that it showed that he was guilty. He wet down the paper and ate the evidence showing that he's guilty. And then he called his wife, possibly crying, and finally revealing the truth to her. Is that how that went down? So I don't know. Can anybody say either now or in the comments after watching this video, which I don't know that anybody's going to get to 2 hours and 52 minutes of it. Can the intern and the investigator be forced to testify and reveal information about what happened April 3rd at the trial? Thank you. All right, we're wrapping this up pretty soon. I don't know. My hope is that there's some kind of resolution as soon as possible. That's always my only hope. KT, your quote, "I killed Abby and Libby" quotes from the calls is somewhat inflammatory. You don't know if it's true, and also if he was reading from a plea offer. From what we've heard, there was never any plea offer given that day. If so, if there's a plea offer, why would Baldwin and Rosie not go April 3rd themselves? Why would they send an intern and an investigator to have Rick do that? I have heard that that is a rumor, that Rick was given a plea offer, and that's why he called his wife saying, okay, I'm going to plead guilty. Or did he go crazy? KT, I'm saying this because McClelland filed this officially saying they transcribed these phone calls. He admits several times he killed Abby and Libby. So do you really think that the McClelland would put that in an official document, and then later at the trial, that phone call is going to come out, and he's not going to admit several times that he killed Abby and Libby? One thing that I brought up in my Frank's Memo 7-hour and 5-minute video was this whole fake quote on page 22 of the Frank's Memo, where it says something like about the privacy between Rick and his attorneys, which I agree with, that they should have more privacy. But the defense came up with this totally fake quote that said Rick would not feel comfortable telling his lawyers something along the lines of, quote, "The guards are telling me my family will be killed if I do not call my wife and confess I killed those girls." That's the end quote. So what stood out to me in that was in these true April 3rd phone calls, did Rick tell his wife or his mom, I killed those girls? And because of that, that is why that whole fake quote was made up in the Frank's Memo to say like some kind of reason why Rick would say, I killed those girls. So that's my reaction to that, KT. I don't think McClelland would lie. I know people just freaked out about me saying that. In that instance, I do not think he would transcribe this phone call and say something that was not true. I know that Rosie at some point said what Rick said was generic, but I don't know. We're going to have to wait and see exactly what comes out. What's going on here? Big Fish Small Pond says people go crazy in solitary. I agree. However, even the defense said Rick was fine in solitary for 5 months. What happened April 3rd to make him go crazy? That he would lie to his wife and his mom that he's a child murderer. The defense said he was schizophrenic and delusional. From what I've read online, men who are 50 years old do not suddenly develop schizophrenia. I don't know. Is anybody here a psychiatrist? If so, can you provide any clarification? What kind of mental illness would cause Rick to be okay for 5 months in solitary, that he suddenly calls his wife and his mom and falsely confesses? I'd like to hear some experts. 3 minutes left. What are we going to finish with here? I'm looking for one final comment before I go take a nap. I don't know what to say here. I'm just looking for one thing that we have not really talked about yet. So yes, I'm stopping this in 2 minutes, but I am coming back at 8:30 Eastern tonight for people who are working right now, and for my Australian people. I don't know. I'm reading some of these comments, but I don't. It's nothing that we haven't really discussed before. Hi, Luna. Where is the proof of what Rick said to the conservation officer? He said he lost the recording. He said he recorded every interview he did, but he mysteriously can't find Rick's. And I've said, well, if he did it with his phone, why don't they use some police software to get all of whatever data from his phone? And I'm curious, why did he not have to turn it into investigators every interview that he recorded? He should have been sending that to the unified command. So why was that not followed? Hi, this account. Thank you. I appreciate you. I saw you before in the chat. All right, it's 2 hours and 59 minutes. Goodbye. Uh-oh. King of spelling and grammar. Yeah, don't trigger me by misspelling in my chat or anywhere else. All right, thank you everybody for joining. I appreciate all the familiar names I've seen. Hopefully this is headed in the right direction. I don't know. All right, that's it for now. I'm going to go watch the hearing again so I can get a better understanding of what happened. Thank you. I'll see some of you later. Again, if you're in this chat, you don't have to come back later. My next live chat will be whenever the Supreme Court issues a ruling. Goodbye. And thank you to everybody who donated. I appreciate you. Bye. My stomach's growling.